guess this is. All right, this is better? All right. Again, my name is Taquan Cates. Again, thank you for having me here and me being able to express a little bit of the law to you all. Hopefully it is interesting. I know sometimes it can be a little nuancey, but I hope to get this through this presentation to you as best as I can. And also, if I start speaking too fast for you all, if I'm going too fast, you're like, hey, you got a question? Just say, hey, Taquan, slow down. I got a question. And I'd be happy to either answer or slow down for you all right? So let's get started. So on the agenda today, what I am going to talk about first is family law, and then I want to talk about estate planning and a little bit of elder law. So first things first, family law. Four different areas that pretty much takes care of family law. That we have child custody, we have child support, spousal support, and divorce. Child custody is one of the biggest ones that we all go through, well, some of us go through, some of the cases that we see on a daily basis. So here's child custody in a nutshell. So child custody cases are heard in the Juvenile Domestic Relations Court. So in the state of Virginia, the Commonwealth of Virginia, there are 4 different courts. So you have the state level courts, you have the General District Court, which just hears consumer law cases, whether it be from person to person, like it's a contractual issue, whether it be something going over a tractor, or whether or not you enter a contract with someone and someone didn't perform on the contract. You heard that in General District Court. Or if there's an issue dealing with unlawful detainer, so like a landlord-tenant matter, that will be heard in the General District Court. And also criminal matters, that's also heard in the General District Court. Then you have your Juvenile Domestic Relations Court, and that's what we call family court. Different states have different names, but in the Commonwealth, we call it Juvenile Domestic Relations Court. And that's where you will hear these child custody cases, the child support cases, and that's where the judge will determine whether or not, you are awarded spousal, child, or custody. And the court, when looking at child custody, what they determine is the best interest of the child factors. And there's a set of 10 factors that I have on the next slide. And these 10 factors ranges. It ranges from whether or not each parent has the ability or culpability to take care of the child, the relationship between both parents, and also whether or not the parent can actually perform the duties of the child in their upbringing or their rearing. One of the things that when it comes to custody, also you have grandparent rights, you have also the non-biological rights or non-biological parent rights. There are rights that individuals who are not the biological parents can gain custody of the child. However, those factors are a little bit different and a little bit difficult to obtain. For instance, for child custody in general, so just between the mother and the father, all you have to prove is the best interest of the child factors. But when it comes to a grandparent trying to obtain custody over a grandchild, or let's say an aunt, uncle, cousin, maybe even sibling to gain custody over a particular child, or the minor child, they will also have to prove that both the mother and the father is unfit. So along with arguing whether or not they meet the best interest of the child factors, they have to make sure that they maintain that it's also unfit parentness. And when it comes to unfitness, that's a whole different issue. So unfitness will look like whether or not that particular parent has a long history of criminal abuse or some type of alcohol abuse, something like that. Those are examples where unfitness will come into play, and that someone can argue that that person is not able to take care or rear that child. And here's all the list of the best interests of the child factors. I know that's a lot, and I explained just very briefly, and I can explain it again. So you have the age and physical and mental conditions of the child, given consideration of the child upbringing, the age and physical condition of each parent, the relationship existing between each parent, the relative willingness and demonstrated ability of each parent to maintain a close and continuing relationship with their child. Because as you may can assume, in child custody cases, mother and father, if it's that type of case, they're just going at it. And sometimes their own emotions gets in the way of actually rearing the child. And what some of the hardest things when litigating these types of cases is not only you litigating for my particular client, the client that I'm helping out, is the child is affected, and they don't know that the actions of both parents are actually affecting what the child. Because child may love both parents, but because mother may be mad at father because father missed a baseball game, or father mad at mother because mother has a new boyfriend who he doesn't particularly like. Even if that new boyfriend is doing everything that he needs to do, it's still an issue, and then that in turns makes a child custody case very difficult and very hard. So oftentimes you will see the difficulty in actually litigating these cases because of so much emotion that goes and involves in child custody cases. And then next is child support. So both cases, so both child custody and child support kind of go hand in hand. So if someone were to file, let's say, a custody petition, but also file a child support petition. What will happen is that the court will consider both, but before that the court can consider child support, they will have to establish custody. Who will the child be able to be with, or who will the child be with the most? And with child support, what a lot of people don't understand, it's very formulaic. It's a formula that the court uses, a set of guidelines that a parent or the court looks at in determining what the monetary amount of child support would be. And it typically varies around how much each parent makes. So if one parent makes $80,000 a year, another parent makes $20,000 a year, it would depend on the parent who actually makes the most and how much, and also other factors that are included is whether or not a particular parent has other children that they're taking care of. So maybe a parent or a child that is outside of that particular relationship, if they are taken care of, they get credit for that. Also, if there is in daycare, any daycare costs, that's also a credit that the court looks at when determining whether or not child support or what the amount child support is. And there's really no arguing in between. So there's a guideline, we call it the child support guidelines. And there's a formula that we use that we can actually go online, put in the information of whatever the numbers are, and they just spit out a number, and we give it to the court. And essentially what the court will look at is that guidelines. If the amount says $500, that's essentially what it is. Now, there's an argument to be made as a rebuttable presumption, and what a rebuttable presumption is that the guidelines are essentially wrong, and that essentially the lawyer or the person or the claimant or the plaintiff defendant has a certain circumstance that doesn't allow that particular person to obtain that amount of money or pay that amount of money each month. And that could be bills, that could be other family-related issues or something to that effect. But typically and generally, the court is very stringent upon what that amount actually is. And either parent can actually file for support. And the next is spousal support. And spousal support, it also is a dicey issue that can also happen in the juvenile domestic relations court. Typically, you see spousal supports handled in divorces, which I will talk about next, but spousal support can happen in juvenile domestic relations court. And at that point, both the husband and the wife have to be separated. They cannot be in the same home in order for one particular spouse to actually receive any type of support. That is also set on a set of guidelines that the court reviews to see whether or not a particular person or spouse receives an amount of money. And some of those factors include the length of marriage. So automatically, another piece that when we're explaining to clients what spousal support is, if you haven't been married for at least 5 years, the court really isn't going to consider your spousal support. They're not going to even give you the day of time. Like, obviously, anybody can file for spousal support. There's no right not to file for it. However, just in general practice and what I see on a daily basis, if you haven't been married for 5 or more years, it is not going to do you any good to file for spousal support because the court is not going to consider it. And that's just an unfortunate thing that the court looks at. The standard of living, so if someone has been living the high life essentially, so if, a spouse who may have been a stay-at-home dad or a stay-at-home mom, if they have been living in a home, $1 million home, and then all of a sudden, something happens where the marriage shifts, the court would take that into consideration of that type of lifestyle. So that will be factored into the amount of money that the court will factor into divvying out. Also, whether or not the age of both parents. So if a spouse is, let's say, 55 years old and have some health issues and they have been out of the workforce, let's say, 20 years, the court will consider that person's age and ability to find new employment. If out in the world they can't really find any employment or learn any new skills, the court will give credit to that particular spouse to see how much money that the other spouse will have to pay for the other person. And also any contributions that the particular, both spouses. So and when it comes to contributions, that can be anything. It can be monetary and non-monetary. Monetary being the money, like how much money a particular spouse put in. Non-monetary, that being providing for the house, whether that's cooking, that's cleaning, that's taking care of the children. With children is also a factor that the court looks at, because if one parent is working all the time and the other parent is taking care of the children, the court would also consider exactly how much time is allotted to the children and how much money that the court can award a particular person or spouse. And again, this can be awarded in divorce. Now, divorce, you have to be separated for at least 1 year. Now, that time can be shortened if both parties have a child during the marriage. So then in that time period is 6 months. And these type of cases are filed in the circuit court. So again, you have the general district court, you have the juvenile domestic relations court, and now you have the circuit court. The circuit court is what we call like the formal court. That's where everyone listens to your case. That's when the judges are really, really, really strict on everything that an attorney does or anyone has to do. The court looks at that. They listen to the higher, I guess, precedented cases. So when it comes to the circuit court and when it comes to divorces, custody, all the things I just mentioned, custody, child support, spousal support, also equitable distribution will be finalized in a divorce. And what equitable distribution is that's the marital assets. That's how much assets has been given or have been obtained during the marriage. Now, there is some type of discrepancy as to when it comes to equitable distribution. If one person is, putting in 50% and the other person's putting in 50%, they believe that once you go to court, it's going to be 50%. It's going to be 50-50. Well, it's not always the case, because in the Commonwealth, it's not a community property state. And what that means is that it's not 50-50. So essentially, if someone were to get married, let's say, and buy a house, but one particular spouse has the better credit, has the most money, and it'll be better for them to look good on a mortgage loan. So they put their name on the home, but they're married at the time. Let's say 3 to 5 years pass, they're married, and then something happens where the marriage is about to go haywire, about to go to the left. Then the person whose name is in the mortgage believes that that's my house. That's my house. I bought that as in my name. I pay all the bills, but that's not the case. The other spouse has an argument, because if that other spouse was actually doing things into the home, like that being taking care of the children, maintaining the home, it doesn't matter, because the actual property itself was actually obtained during the marriage. So it's considered marital property. It's not outside of the realm. And that also goes for cars or any type of loans. So if someone were to purchase a car during the marriage and it's in one person's name, that other party can get some type of either lien or have to pay out an interest of the loan to get the other person to either back out of the deal or to get their name removed. So I always tell clients, and clients are always upset about that particular issue with the law, but unfortunately, that's how the Commonwealth looks at it. It's if you bought it during the marriage, it's marital property. The only way that it's not marital property is if someone inherits something. So if someone dies, so for instance, if father passes away, and he has a lot of money. And she inherits, let's say, $3 million, but they're married at the time. The husband, if the marriage breaks down and they are filing for divorce, and the husband says, well, I got this $1 million settlement, the wife got this $3 million settlement, I deserve at least half of that. The answer is no, because it's inherited. And inherited property, anything that is inherited is not part of the marital asset because it actually happened before the marriage. So there's anything. Now, it gets dicey, and this is where the nuance comes. It gets dicey if half of the money of the settlement money or the inheritance money is used for the marital home. That's where the issue comes. That's where the argument of the person that didn't obtain their inheritance can make the argument, well, the house was used for my marital property. So therefore, I should be entitled to some portion or some amount of this money. And that's where and during this whole time period, you're also dealing with the feelings and the emotions of what's happening from both parties. So I always tell clients, you have to be patient, but also understand that this process is going to take long. And some of the clients that come to me about, I'm ready to get divorced, and sometimes, they've been through a lot, which, I always understand and, sympathize with them in that regard. And also sometimes, and because of all maybe the heartache or whatever is going on in their particular lives, they want the divorce happen. So if they come to me on yesterday, they want to get divorced the next day, which I wish that happens, but it doesn't. Sometimes divorces takes a very, very, very long time. Divorces can last for years. I mean, I'm sure you've heard of stories, you've heard of celebrities, you've heard of people that you may know who divorces have taken 3 to 5 years to finalize. And that's because divorces are hard. They're very difficult, and they're very complex. And it's complex because if there's marital assets and both of them have a lot of property, or they have kids involved and child support, like all these things, that's just what's going to take a long time. And what I tell my clients to do, and this is just from a practical standpoint, in which I think most attorneys and most people should tell people when they come to attorney offices about divorces and things like that, and kids are involved, is to take care of child custody, take care of child support, and take care of spouse support before you file for the divorce. Because if you take care of that before you file the divorce, then that process of the divorce would streamline to maybe from it being 2 years or a year to maybe 6 months getting done. So that actually makes the process a lot shorter if you take care of child support, child custody, and also spousal support before you actually do the divorce. So I always tell clients to please get that done let's get that done before we file for that divorce. Another thing when it comes to divorces, and because it's a nuancey thing, is if there's a child custody case, it's a very highly contested child custody case, if it's in, as I stated before, the juvenile domestic relation court, some strategic attorneys and some shady attorneys, depending on how you view it, if there's a highly contested, just say custody case that has been going on for like 6 months, and you're about to have the hearing, so the hearing could be maybe 10 days away. The spouse who's upset with the other party files for divorce within that 10-day frame and alleges custody being at issue. What happens is the juvenile domestic relations court loses jurisdiction. And what that means is that it no longer be a case before the juvenile domestic relations court. It goes straight to the circuit court. And that could take that process to be long. So when you almost are done and finished with child custody, if you're almost done, it's pretty much null and void, and it has to go to the circuit court, and you have to pretty much start the process all over again. And again, depending on who you are and how you view it, it could either be a strategic thing or a shady thing, one of the two. But it happens more often than you think. Now, I will pivot to elder law and estate planning. Yes, sir. Yes, sir.
So, in that case of the custody,
yes.
Is there temporary custody until such time as, kids have to be taken care of, right?
Yes.
Do they offer some temporary solutions in that case?
Yes, sir. So there can be a temporary, well, it depends. So a temporary order can be entered in the time frame from which it removes from the circuit court to now. Like that can happen. However, the party has to request that a temporary order be put in before it goes to circuit court, because once the judge finds out that circuit court has it, the divorce has been filed, they are obligated to stop doing everything But if a judge, if an attorney or if a party does not raise the issue of what you just stated, my kids, we need to figure out something in the interim. If they don't say anything, the judge is just going to say, hey, my hands are tied, it goes up. So temporary orders can happen, but only if you ask for it. Only if you ask for it. And the judge will only intervene if there is a serious matter, a serious issue between custody, and that being if the court feels as though the child will be in danger being with the other parent. Then that's when the court would impose its own order, or in the legal term, sua sponte. That's when they will issue their own order. Absent that, they're not going to do anything. No problem. Any more questions? Yes, sir.
When a divorce is in the process and one of the parties does not work in good faith, not the lawyer, but one of the parties of the divorce, and you are always at your point of time when they say meet, they meet, and the other party just don't show up or do not attend or do not have the good intention to allow it to move in the right process. How do one get the other party to move in the right process without hurting oneself?
So, if I understand your question correctly, it's going to be a layered answer. So, if another party isn't acting in good faith, then what typically happens, if it's a strategic lawyer and good attorney, what will happen is, if they're on the other side representing against the unfaithful person, what will happen is if there's any type of litigation, so let's just say in divorces, as an aside, you can have what's called a pedente lite hearing, and what you just explained or asked earlier, a pedente lite hearing is a temporary hearing, and what that temporary hearing kind of expands upon like the custody, the child support, spousal support in the interim before the divorce is finalized, before they have a final hearing. So, if a person isn't operating in good faith, and there's something foul and they don't say show up to court, that's almost a windfall for the other party. So the other party would essentially, if it's custody at issue, they would get full custody. If child support at issue, it's whatever the amount said on the guidelines. If it's in favor of the person who is not being faithful, then what will happen is they will likely either dismiss the case, dismiss that particular petition, or if it's in favor of the person who is being faithful, then they enter it. So it behooves the person who's not acting in good faith to do everything that they can, because there are ramifications that either losing everything or essentially being comfortable with the outcome of not getting what you want. That's the issue. Now, from the side of representing the person who is being not acting in good faith, that creates issues on the attorney part, and I've had issues like that before in the cases I've handled. First, as an ethical standpoint, I have to advise the client on what they need to do, what should happen, and do everything in my power to let them know, like, if you don't go to this is what's going to happen. But if they're not acting in good faith, then it goes back to what I said earlier, the ramifications of them losing their home, losing their kids, losing any type of amount, that would just happen. Or the other party can file what's called a show cause. And what a show cause is to bring that person to court. And they'll have to answer to the judge as to why you didn't show up for the court. And show causes are not something that a party wants. So show causes can be a civil thing. It can also be a criminal thing. So if on a civil side, let's say, for instance, if someone doesn't show up, then there's a fine that can be associated with it. But if on the criminal side, if the party who is suing for the show cause asks for criminal sanctions, what can happen is, and judges really, especially when it comes to divorces and family law cases, they don't like to issue criminal sanctions when it comes to show causes because it could hurt the child if a child is involved, or it could just hurt the process. But if that person is being really unfaithful or not acting in good faith, then they will give them some jail time until they comply with whatever the order is or comply with whatever is going, because you're obligated to come to court. You are obligated. And if you don't, you either risk losing everything or if show cause, getting sanctioned for it. So those are the ramifications of someone not acting in good faith. Any more questions? All right. So why do you need a will? Why do you need a power of attorney? Why do you need an advance medical directive? These are 3 documents in which I think everyone should have. Whether you're young, whether you're in the wiser community, I think that you need it. And here's the reason why. It protects your assets. So when it comes to, let's say, your will, protects your assets. So you don't have to worry about when you pass away, because we all got to leave here and go to glory. When you leave here, you don't have to worry about who's getting what. And you don't have to worry about the family having issues about who is getting what. It gives that person peace of mind. They all are designed in a way, both from will to advanced medical directive, they are designed in a way to meet the client's needs. And I'm going to explain the difference in all 3 documents, but it's imperative, I think, that people get this done because you never know when it's your time. Or you never know that you're going to be placed in a situation where it's going to be necessary for you to have these documents. So let's start with a will. A will is a legal document that stores a testator's wishes and instructions for managing and distributing their estate. Who is the testator? The testator is the person who is essentially getting the will drafted for. That's the person whose assets and benefits or whatever they have is being distributed out to the people that they want. The executor is the person that they entrust to manage their estate or manage the distribution of whatever that estate is. So it's the person who someone trusts to give, their family heirloom to Joe, or their favorite baseball hat to Jasmine. And then the beneficiary is anyone actually receiving it. So if, let's say mom dies and mother has 3 kids, she has a collection of hats, she has a collection of shoes, and she has a collection of dresses. Jasmine gets the hats. She can put in a will. Jasmine gets the hats. Tiffany gets the shoes. And then Ashley gets whatever is left. So, and again, wills, I can't stress enough, are so important because if you don't have the will and you have a bunch of assets, so let's say that you have a business interest, or you have 3 homes, or you have just 1 home, and there are 5 different people who are fighting over this home or fighting over these assets. If you don't have a will, you're going to leave it up to the Commonwealth to make that decision for you, and we don't want the Commonwealth to do that. You do not want the Commonwealth. So there's something called intestacy, and what that is that you die without a will, and there are certain laws and there are certain statutory things that will go to specific people that will divide your estate for you. For instance, it gets nuancey because, for instance, if mother has 3 children, married to, and mother and father has been married for 20 years, mother passes away. She has 3 kids. One of the children was born outside of the marriage. And mother dies. So that leaves 3 children and a husband that's left. And mother also has a house, she has some assets, she has a lot of money. And all of this money, and father just being nice, or husband is being nice, doesn't really like the person that was made outside of the marriage, but just, accepting the child because the child is here. But once the mother dies, then that husband thinks, well, all of this is mine, all of this goes to me, and I give it to my children and kind of forget about the other child. Well, that's not the case, because all of the house, all of the money, all that doesn't always go to him. A portion of that goes to the child outside of the marriage, and it's nothing that he can do with it. He can draft his own will and says that my children can get this. My child can get this. My 2 children can get this. But if all 3 children are mother, that other child is still entitled to that. So his will can be contested, because although mother didn't have a will, and father has a will, that doesn't mean anything, because that child can still contest it, and he or she is likely to win because they're entitled to it. But to prevent all of that from happening, you have a will. You have that in there. And I'm sure you all have heard of stories where the family goes crazy about different things. So that's why a will, I say, is so, so important to have. And there's also a thing called a trust. And a trust, some people do have. And what a trust has, the difference between a trust and a will is wills are probated. That means it goes to court. And I'm going to explain what probate and non-probate is in a second. But just very briefly, trust, you don't have to necessarily worry about the court. It's primarily done in the trust. You don't have to worry about privacy in a sense, because once you probate the will, so once your executor probates the will, it becomes public record. So like you can go online, go on the court's website, see when the person died, and then actually review the will to see, what goes where. With a trust, you don't have to worry about that. It protects your interest, and you don't have to worry about people knowing everything that you want to have. But I always still advise for a will, having something in place. So when it comes to probate assets, I just explained, everything just can't be put into a will. So there are certain things that can be put into a will that the will cover, and there are certain things that a will will not cover. So things that the will cover, that's real estate, that's like a home, that's bank accounts that aren't joint, which I'm going to explain in a minute. That's tangible personal property. So if you have like a favorite chair, you have a car, you have a business or something like that, that's stuff that can be probated or can be devised in a will. If you have stocks, you have bonds, that can be devised in a will. And any motor vehicles or anything like that, that can be probated, and the will can cover. Now, non-probate assets, which are assets that a will just absolutely can't touch, you can put it in your will, but it doesn't matter. So joint bank account. So if you have a bank account with someone, so Jasmine and Jamal has a bank account, Jasmine's name's on it and Jamal's name's on it. Jamal dies, but Jamal has in his will that all the money is to go to his child. Well, the child can't get that money because it's Jasmine's, because they're joint bank accounts, and you can't do anything about that because it's already a contractual relationship between Jasmine and Jamal once the account is set up. The trust assets, payable on death, design assets, so that's like life insurance things or things like that. They already come with their own policy. So like there's already a beneficiary listed in the policy that you get. So again, same fact pattern. Jasmine has a life insurance policy, names Jamal as a beneficiary. Jasmine dies, wants to give it to her children. Children can't take the money because Jamal is the beneficiary of the life insurance policy, so he gets the money and not the children. And there's nothing anyone can do about that. And yes, sir.
Is the payable on death, is transfer on death included there?
Yes. Yes.
How often should you have a will
So it's a case-by-case scenario. So if, there's something that you want to change, so like that's, you fell out with someone, you're not friends with someone, or this family member you don't think that deserves whatever you have, then I advise that you get that updated immediately as possible. So in essence, maybe every 5 to 10 years, reread your will, make sure that it's everything that you still want in that will, or you want distributed to the people that's in the will, to make sure everything is essentially kosher. And if it's not, then I would advise that you immediately get that redrafted. Now, when it comes to a will, that can be done as many times as you want. You can literally, so in order to terminate a will or revoke a will, you can write on it, rip it up, or draft a whole new will. So you can draft that as many times as you want. If you made a will today and it's valid and executed, the next day you say, you know what, I don't like this person anymore. I want them taken out of my will. You can do that too, and that second will be valid and effective, and the other will no longer matters. So I would advise every 5 to 10 years, just review it, make sure it's everything is you want in the will. If not, get it done. Get it taken care of. Now it comes to a general power of attorney. Now, what is a power of attorney? That gives another person, which would be called an agent, the ability to handle your financial affairs. I'm going to talk about the difference between this and an advanced medical directive, because most people get it, I guess, confused with, taking care of like the medical issues. Power of attorney doesn't take care of that. That's what advanced medical directive does. But a general power of attorney that takes care of your financial needs. So like that's, maybe opening up a credit card account. That's maybe buying a home, opening up a loan, or doing anything on your behalf, or answering calls, or doing whatever that is necessary, or doing business for that particular person. That particular agent should be someone that you trust. It should be someone who may be financially stable, or financially, I guess, competent to make sure that everything is happening the way that it should. I've seen instances where an agent the person wanted the power of attorney drafted for them, believed this particular person, felt like this person was going to do everything that they needed to do. When it came a time where it was time to invoke the power of attorney, that agent didn't do anything that the person said that they wanted to get done. And that caused an issue, which comes to, and this was an elderly issue, where it becomes like, it could be elder abuse, which is a criminal statute that can happen. So I always tell people, whoever that agent is, they should be someone that you trust. And when I'm drafting these different documents, whether it's a will, power of attorney, and especially advanced medical directive, I have my initial consultation with them, explain what the different options that they may have and what they are, and start asking questions on what they want in these documents. And always, get whatever they need. But after I finish talking with them, I tell them, look, I give you another week to make a decision about if this is something you want. So when it comes to power of attorney and advanced medical directive, because they're so important to your life, they're so important to like your daily livelihood and who's going to be taking care of your assets and things of that sort, you just can't make a brash decision. I always give them a week. They may have already made a decision, but I just want to make sure that they're making the proper decision at that particular time, because I don't want to ever draft something that they're not ready to commit. And I've had clients who I've drafted something and they said, Mr. Cates, I know we talked about this, but I need some time to redo it. I was like, I understand, because this is something that is very, very important. When it comes to power of attorneys, a lot of people don't know is there's different types. So you have the general durable power of attorney, and what a general durable power of attorney is it is a power of attorney that doesn't elapse once someone becomes incapacitated. So if someone is deemed incompetent by a medical professional, it doesn't cease to exist. Some power attorneys are drafted, which if you want everyone one done or drafted, make sure that it has this language in there. Actually, the Virginia Code actually states that you have to have this particular language in the power of attorney, but some power of attorneys just doesn't have it in there. So if it's drafted and validly executed and that language is not put in there, then that power of attorney stops when that person becomes incapacitated. So it's always imperative that someone use a general power of attorney and make sure that language is in there. So once someone does become incapacitated, it doesn't go away. There's also something called a springing power of attorney. What a springing power of attorney is that only happens, it only comes into effect when that person becomes incapacitated. It doesn't happen right then and there. Because most people think once you get in a power of attorney done, all right, that person can start making decisions on my own, and that person may not be ready for that person to do it because there's nothing wrong with them. They just have this document in place just in case something happens, and they have to make those decisions. Because if you don't have a spring-in power of attorney, and once something is if it's a general durable power of attorney, that person who you name as your agent can start making decisions on your behalf, and there's nothing that you really can do about it. So they can call some company and say that, my mother, my brother, my sister wants this, and that company asks, well, do you have a power of attorney? Oh, yes, of course I have one. That's what goes back to trusting your agent. That company said, okay, well, seems like everything is good. Here's it goes. Then the person who has the power of attorney drafted sees either draft in their account or sees something on their credit that they didn't approve. That's going to cause an issue. So if you draft it in a way that is springing, then it will not come into effect until a doctor has deemed you incompetent, that you can't make your decisions. And I would say that that's mostly the power of attorneys that I draft. I have draft general power of attorneys because it's always the client's decision. It's not my decision. I just advise and do what clients tell me to do. But that's after I do explain what spring-in power of attorneys are. If they elect to do the spring-in, then the one that comes right then and there. Not only that, although they still trust that agent, you just never know. If you are still willing and able to make your own decisions, you make your own decisions. Don't let someone do it until it's time. Yes?
How do you know when you reading through that whether you have just the dual or you have the springing? Is the wording different? Is springing in there? How do you know the difference?
Yes, ma'am. So it's language in there. So the way that I drafted, again, different attorneys do things differently, but drafting matters. So words matters. Like in our profession, words matter. So in mine, there's specific language that I say in my power of attorneys that this power of attorney does not become effective until there's medical evidence proving that this person has been deemed, or whoever that client is deemed incompetent. And if that language is not in there, I still add the language with a general durable power of attorney because I don't want it to elapse once they actually become incapacitated because they would die, as I said earlier. But this is also with these documents, as I mentioned with the will, it can be drafted a multitude of times. So, and the way to terminate that is you can rip it up or draft a new one. But yes, I think that's how you understand and differentiate between what a spring-in power of attorney is and a general dual power of attorney is. And this is, yes, ma'am.
I'm sorry, on the, you said that if you want to change your will, you have to get that upgraded, I forget the term you use. If I don't, and everything stays the same, do I still have to have that reviewed?
What do you mean? Say your question again.
If I had, like, my will's done, and if I'm not going to make any changes, like, as long as I'm in my right mind.
Yeah.
I don't have to have that reviewed?
No, you don't have to. It's purely a decision on you. I was just saying, as the gentleman asked the question, if I just say that you review it yourself 5 to 10 years, every 5 to 10 years, just to make sure everything is good. But you don't have to do it if you don't want to. It's just, I guess, peace of mind because you don't want to give something that you don't want to give someone to. So, no problem. Yes, sir.
How many doctors does it take to
So it only takes one. It only takes one. And it can be a litigated issue because different area of the law, guardianships, but a doctor can deem you incompetent, but the other says no. So if it comes to like a will issue, you just contest the will, and then once you go through the litigation process, you bring that doctor who's done the competency evaluation to see whether or not that person is competent, and you just make the argument there. But it only takes one doctor to deem you incompetent for a power of attorney to become effective, will, things of that sort. So just one, but it can be contested in court, and that will go to the circuit court. Does that answer your question? Okay. Advanced Medical Directive. Again, that's easily confused with a power of attorney, but the Advanced Medical Directive is the document that you give your agent the right to make decisions in regards to your medical needs. So that's end of life instructions. Some people don't want to be resuscitated once it becomes a time where that is necessary. You either give, so you can put in your Advanced Medical Directive exactly what you want. So if you have a non-resuscitation in your Advanced Medical Directive, then you won't be resuscitating, you just die then. However, if you put yourself, or if you want your Advanced Medical Directive to be, say that I want to use any life-prolonging procedures to be done just long enough for me to go home and pass away, you can put that as well. Or you can just say, I want my agent to make that decision for me, I don't want to make that decision. So there's options that I put in my Advanced Medical Directive to give that particular, well, I tell them, and then they tell me what to put in there, but I give them those options to make the best decision on their behalf. And again, I give them a week to make that decision because it's a very important thing. Also, the agent of an Advanced Medical Directive can also, if you're in a hospital and family issues, friends, people falling out for whatever reason, you can put in your Advanced Medical Directive that your agent can tell a particular person not to come to the hospital, or let the agent make the decision for that person. But again, for Advanced Medical Directive, that agent has to be someone that they trust. Also in Advanced Medical Directive, you can, if people want, have your body donated to science, or have your body examined by anyone, or just not have your body examined at all. You have those options in Advanced Medical Directive. You also have the ability to say who has the right to make decisions on your behalf as far as in like your kids or anybody else. And the doctor, and I've had questions in the past about doctors not abiding by the Advanced Medical Directive. Some doctors, and this is just a point that I like to tell people when I give presentations and things like that, is when it comes to Advanced Medical Directives, if a doctor, and you have one drafted and it's validly executed, if a doctor tells you that, well, no, I have my own form, you need to get this signed the way that I want it, or there's a form that the hospital actually has that has whatever information that they want you to have, and say, well, I'm not listening to yours, you have to do it my way, they're completely wrong. Your Advanced Medical Directive is yours, and they have to abide by it. You don't have to go by anyone else's Advanced Medical Directive but yours and the one that you drafted, because some doctors will tell you that.
Would that be an unauthorized practice of law
For whom?
for the person who wants to change things? You have to do that with a lawyer, not a doctor. Right?
Yeah, so yeah, and that leads to like other litigation, like that'd be medical malpractice. So yeah, you can sue the doctors or the hospital, whoever, if someone does that.
I have all of these things done. I've got my will and all of these things. But I would share with everybody in this room that it's very important that you have a good Christian lawyer, a good Christian psychiatrists, and I mean that with all my heart. It does make a difference.
Do not disagree with you whatsoever. I do not disagree. It's very important. It's a very important document. It's all three, very, very, very important. All right, so just in summary, will is just a legal document that expresses a person's wishes of how they want their property to be distributed upon their death. Power of attorney that provides authorization for an agent to make financial decisions on someone's behalf. An advanced medical directive is also just a legal document, but just pertains to the medical issues and things like that. And also, I just like to add, and I said it before, but I just want to really reiterate that there is a difference between the power of attorney and the advanced medical directive. A power of attorney does not mean that they can make medical decisions for that particular person. Advanced medical directive means it only pertains to the medical issues and not financial issues. So if someone wants to make a decision who has a power of attorney but don't have an advanced medical directive, says that, well, I have a decision to make, medical issues, that's not the case because they only are in charge of the finances. They're not in charge of the medical. Oh, yes.
The advanced medical director person, does this person have to be well versed in medicine or medical? Or does that just someone that a person choose to make a medical decision for them? Does it make a difference?
No, it doesn't. It doesn't make a difference. So that particular agent does not have to be someone who's practicing medicine or anything like that. If you have it, great. That's a great person to have as an agent, but they don't have to have any level of sophistication to actually perform the duties of an agent. It's just, again, goes back with this beautiful lady just said, please,
It's really
important that it be a Christian person. Oh, go back. There we go. Beware of scammers. Beware of scammers. I put that there because it's important when it comes to like elder law. It is important because they like creditors, businesses, organizations, your family, your friends, they like to prey on the wiser community. They like, in general, they like to prey on anybody. But you have to be aware of these people because they can really take a hold of your money or take a hold of your life. And in some ways you can get around it, and in some ways you can't. And that goes to consumer law. So as I said before, creditors, organizations, individuals, they can get whatever they can from from anybody, especially the wiser community. They like to tell you that your product is, the best out there. They like to tell you that their business is the best that you need. Like, that's the best. This is what you need. This is what I have. You don't need nothing else. You have life insurance policies that are out there that actually try to prey on you to get these life insurance. So you can actually go after different life insurance companies. It takes a lot of money, it takes a lot of work, but you can. And what happens in the future, once someone actually gets money taken away from them or a large debt, that means that creditor can now come after that person. And that leads to garnishments, that leads to judgments, and that leads to other legal ramifications. So when it comes to garnishments, that's someone garnishing your check. Now, when it comes to garnishments, if you have disability, then they can't come after you because you're judgment proof. But people who are working, that's a different story. They can garnish up to 25% of your wages. And there's really no way of getting around that. And a lot of garnishments, unfortunately, I see it every day, a lot of garnishments happen when someone missed a court date that's maybe that happened years in advance. Well, years in advance. And they said, well, I never, heard anything. Like, I never received this, summons or anything like that. So how can I have this judgment? I never heard anything about it. But now they see this new summons that had a garnishment. Now their wages are getting garnished. And the first argument to always be made is, well, again, I never saw this. I never agreed to paying this amount. I never agreed to any garnishment. So they think they'll have their day in court with garnishment. But that's not the case. So garnishments, that's what they are. You're going to get garnished. And once the garnishment are happening, you have a right to contest it, but there's a particular and very stringent law that gets you out of paying or getting your wages garnished, but most of the time it doesn't work. So it doesn't matter whether the court case happened years ago. That doesn't matter, because what's important right now is the garnishment, and there's nothing the court can do about it. Whether it was unfair, whether or not you may have a valid claim that you never received the summons, but that's not the time to do it, unfortunately.
Yeah, I'm not clear on who's getting their wages garnished.
So for instance, I give you an example. So if a creditor, let's say Symphony Bank, came after Joe and says that they owed him $10,000, and then set up a hearing to argue about the $10,000. Hearing happened, Joe doesn't show up for court. And then 3 years later, Symphony Bank comes and sues Joe for that $10,000. And then Joe has been working this job, probably making, let's say, minimum wage. Boom. That Joe starts getting his wages garnished by Symphony Bank. And they're going to get as much money as they can from him, even though the judgment may not have been something that was valid, or he just missed a court case. So that would be the person who's being garnished. And also, I like to say when it comes to like elder law and when it comes to consumer law, that a lot of people don't know, when it comes to litigation, when you're fighting these companies and these businesses, is once, again, like Symphony Bank, given that as an example, Symphony Bank is just a law of corporations. And let's say it's $10,000 debt. They can sell that particular debt to someone else. So it's a second party or third party that is here, and they pay maybe, let's say, $1 for the $10,000 debt. And then that third party says, well, I don't really want this no more. I want someone else to take this loan. So they again paid 50 cents for this $10,000 judgment that they be entered. So I say all that to say, you can have 5 different people who's taken over that judgment. That fifth person, or that fifth company, can still come after Joe for that $10,000. And a lot of creditors prey on that because they're still getting money. They're getting the money regardless. But if someone is willing to pay and take the debt off them, creditors just going to allow them to do it. Like they're going to take the money and let someone else deal with the hassle of taking them to court and doing things like that. But a lot of credit, and then that's another argument that Joe will have is, I didn't enter a contract with Jasmine's landscaping business or Jasmine's creditor association. I didn't do anything. I don't have no documents pertaining. They could have the contract drafted up. It doesn't matter because they bought the loan from Symphony Bank or whoever the other creditor was before them. And a lot of creditors do that, and they take them to court, and they get the judgment amount, and then that's when the garnishment starts happening. And it all starts from creditors preying on people, and especially the elder community. They will take as much money. The sad thing is they can come after your home. They can come out of the mortgage. They can place a lien on it. They can come out your vehicles. They can come after everything that you got. And there's really nothing that you can do about it unless you understand at the onset of what is happening, or have someone who has at least understanding and kind of knows of what a scam is likely, or a scam is likely happening. So if you ever feel like, or so you know someone who's ever feeling like this deal sounds too good to be true, it's likely the case. It is likely the case, and I will either contact an attorney or contact someone, call me if you want me to, or contact someone to see if this is a real legit scam or something like that.
So if the contract says you got 3 days to change your mind, that might be a tip-off that there's something wrong with it.
Yes, yeah,
You better do something within 3 days.
yes, yes. All right, and the last thing I'm going to talk about deals a little bit with the elder community, but it also deals with everybody who needs disability. Not an area that I practice is disability. Two separate disabilities. You have Social Security supplemental income, or you have Social Security disability insurance. And there's a difference between the two. Social Security disability insurance, that involves the amount, so you have to have put in your money into the government. Like you have to pay, your taxes and things like that. You have to place a certain amount of money and pay that into your work history in order to even qualify. So if you don't have a large work history, you're not going to be able to qualify for disability. Social Security disability insurance. And there's no limitations to the amount of resources that you may have, which comes into play when you're talking about supplemental security income. You automatically qualify for Medicare, and when determining what a disability is and what Social Security deems as a disability, it has to be a severe impairment that significantly impacts their ability to perform basic work activities. And I would say, just based on my litigation of these types of issues, Social Security, they're terrible, to be quite frank. They're terrible to deal with. They're terrible to even negotiate with, because when it comes to understanding what a disability is and what they deem as a disability, you can literally, be on your last breath. Your last breath, can't walk, can't do anything. Social Security will still say, no, you can still get a job. You can still fold napkins. You can do that. You can do that. And unfortunately, it happens all the time. And I get so frustrated dealing with them because it makes absolutely no sense. So it's a pain to deal with, but it's something, I still enjoy litigating because I like to see the faces of the people that I help. And when it comes to supplemental security income, that is resource-driven, that is resource-based. That comes with resource restriction, however. So those individuals who don't qualify for Social Security disability insurance, so they don't have a work history, but they're still disabled, they can't make more than $2,000, so have $2,000 in assets. So if you had $2,001 or $2,001 in assets, Social Security won't deem you as getting supplemental security income. It's also capped at $914, so you can't make no more than, or you can't get no more than $914 when it comes to SSI. But when it comes to SSDI, that amount varies just depending on work history, whether or not you care for someone, whether or not you have your own home, things of that sort. So that range can go up, but when it comes to SSI, it's capped at $914, and you automatically qualify for Medicaid as well. All right, that concludes my presentation today. Are there any questions that anyone has? Yes, sir.
Husband and wife, should they make separate wills or do one for both?
Make separate wills. Make separate wills to protect all assets. Because there have been times, again, where, wife has, extramarital issues, or or even before the marriage, just had a child outside of the marriage. And if you want that protected, in regards to the mother having or dad having, you know, a child outside of the marriage. If you don't want that child to, you know, be without or don't mind that they have certain assets, then make sure you have two wills, two separate wills. Always have two separate wills. All right, you and then you. All right.
All right. What is the difference between being added to a checking account, like a parent's account, because they're just getting aged, versus power of attorney?
So power of attorney and with the checking account, that's just a matter of just with the bank. And it's just, they can't make any decision outside of the banking. But when it comes to anything, well, for a power of attorney, that covers everything, not just banking. That covers making phone calls for that particular person. But when it comes to someone being added on a bank account, then whoever is added on the bank account can only make the decisions or handle the account of that particular person. And that's it. I think you first, you, and then you, and then you. All right, yes, ma'am.
Mine's a Medicaid question. I understand Medicare because I'm on Medicare. I get these things in the mail about saying you might be qualified for Medicaid, and then you have to answer this like 2-page questionnaire and
Yeah.
all that. And I don't own anything except my car, but I have money investments. And I told them all that I was truthful with everything, and they said no. They said I had too much money, I can't get it.
There are income restrictions and things that they count into Medicaid. However, I would say if that's really what you wanted, some of the times you have someone who just reading something and just looking at a number and saying, well, this person don't really qualify for Medicaid, or they see your questionnaire and say, I deny them. But if you appeal it or do whatever you want in regards to like filing for Medicaid or something like that, then you'll likely get approved. So I wouldn't, if you want Medicaid, I wouldn't stop going for it, but if you do, I wouldn't worry about it.
Well, isn't that like they hold your, like they pay for your bed or something if you have to go to a facility? That's
Yeah.
basically what it is.
Yeah, it is essentially, because with Social Security, they actually deduct from your pay. So like if you receive $1,000, they could take $500 and you just have $500. So yeah.
So what happens if I would have all that money taken out of my name and my beneficiary would take care of it? Would I get Medicaid that way?
Talk about a deciding woman.
Well, my father's lawyer, he had a really good lawyer, Office of the Aging Lawyer, and he suggested to him right away, spend all her money. Get all that money spent and put somewhere else.
Yeah.
A different person's account.
That gets dicey. I don't want. I'm not gonna say that attorney is wrong. I don't know that attorney, but I'm gonna leave that there. I'm gonna leave that there.
Having gone through some process with the trust and stuff, now they're telling you, you have to do that before 5 years.
Yeah.
Do what?
It's a 5-year limit on that. You can't, like, if you want to leave your, to give your money away, or, you know, put it in somebody else's name, it has to be before 5 years.
Before 5 years, so you
Before
have
5
to,
years.
goes with
You
the
have to
facility?
do it,
Is that what you
if
mean?
you do it, and you have to wait 5 years, or they won't consider that. That's how they told me it when I was here. Because so many people were doing
I
it
got
that
you.
way.
Yeah, okay.
They put a 5 years.
Okay, gotcha.
I think you're next.
Just a real quick question. You mentioned guardianships, and I don't know if anybody in here is concerned about that, except maybe for our kids and grandkids, but where does that fit in here? Is that in a will? Where does that, how does that, is that a separate document, or?
So guardianship, and I didn't put that up there. They had mentioned guardianship, but I do know guardianship, and I've done guardianship. So guardianship is a whole separate legal matter that you will have to file in circuit court. And that only deals with like essentially you also handling like the care of that particular person, but that person has to also be deemed incompetent by a medical professional as well.
Well, what about in the case where we both died in a car accident, and what happens, who takes care of our kids when they were little? I mean, would that be a will situation? Or?
So yeah, so actually I'm glad you brought that up. That's a scenario where I wasn't expecting to hear, but I know how to do that. And
Supervise our kids.
yeah, no worries at all. So with that being said, so if something like that were to happen, and since those particular children are minors, what you can set up in your will is to have someone, like, let's say a best friend or someone that you trust, to take care of whoever the children are. And the court will honor that because it's in your will. And so you can set up a guardianship through your will. So you can do that when it comes to that. You can set it up, but it has to be very particular language placed in the will, because typically a guardianship only revolves around like whether or not someone is deemed incompetent. But when it comes to minor children, it has to be in there such that everybody is put on notice that this person needs to take care of. All right, I lost count.
You, as my wonderful lawyer, would also be writing the medical directive. You would be doing that, right?
Yeah.
Because you would be writing it as I would want it. In other words, if I wanted to just last a certain amount of time and pulling the plug and all that, you would be writing that document,
Yes.
right?
Yes. All right.
On the power of attorney. Now, doing a power of attorney, you've given one person for everything you have, right?
Mhm.
To this particular day. But you don't have a will, and if that person passed away with no will, how effective is that power of attorney then?
No longer becomes effective.
So everything goes to probate then?
Yeah.
Yep.
Yeah.
Everything will, yeah, good. Then if he dies without will, it goes to intestacy, and then the law dictates, or the Commonwealth dictates what gets what. But the power of attorney immediately stops, and it's no longer effective. And whoever that power of attorney, I'm glad you brought that up, whoever that power of attorney is, who thinks that they can distribute the estate the way that they want to, can't do that because they don't have the authority to do so, because a will wasn't drafted.
I have a question. It's for the people with the language barrier. There's a lot of like our native people. I'm from actually South Korea, and I have a lot of Korean elderly lady and men, and they have an issue because they don't know how to go about it. So they like to pick individual. For instance, for me, a lot of people in the community ask me, and then sometimes I was running into, this is individual case. So what do they need for me to assist them? What kind of document do I have for them, to help them translate and take to the lawyer like you, and so I can represent them and explain it to them? And do I need any kind of paperwork, some kind of document, so I can take that individual to you?
So when it comes to so for instance for us, we're operated by and we're ethically bound for attorney-client privilege. And attorney-client privilege means that any communications that happens between, let's say, you and I can't say anything to no one else. And if you bring another person in there, that breaks the confidentiality and it pretty much just be on you. So attorneys would typically tell you or ask you for a power of attorney. They will ask you, they will ask you for some type of authorization or some type of document, and that's mainly a power of attorney so they can speak to you about whatever issues. Because we do have clients who call, or so like their siblings or a friend will call on their behalf, make an application, but we always tell them we can't tell them anything unless we get authorization from from the other person. The other person can also like orally tell you that, but it's always good to have a power of attorney as well. Yes, ma'am.
So can we just as individuals call Legal Aid Society of Virginia and get assistance, or is there a financial threshold or?
Good question, good question. So I'm going to leave some applications. I actually brought some applications with me, so I'll leave it with you all. But with legal aid in general, you have to be under 125% of the poverty line, and our income guidelines that we go by. And we also can make deductions depending on what there is. Now, if you're over a certain age group, there's more deductions that we can make in order for you all to receive services from us. But it goes through, so the way that process takes is, it goes through our intake process, and they will either contact you or look at the application, give you a call to get more information about your income, essentially, to see if you're eligible for our services, and then that's where the process goes. But it is capped as an income, just depending on how much you make and what deductions can we work with to get, so you can get our services, essentially.
Wills and trusts.
Yeah.
Is a trust a lot better to have than just a will?
So it's always, it's personal preference, I would say. If you don't want to deal with the court, if you don't want to do anything with the court, you don't want your will probated, then I would advise that a trust is something that you get, because a trust, you don't have to deal with the court. You don't have to deal with your will getting probated. It automatically is operated through whatever the trust says, or whether the trustee does. Now, you're putting essentially, like with an agent or executor with a will, you're putting your trust in the trustee. And the trustee has to be someone, again, that you trust, and that person needs to understand what a trustee has to do. It's a lot more nuanced than a will. Will is a lot easier to handle and navigate than a trust, but trusts are also more expensive than a will. So you will pay a little bit more to set up a trust than you will creating a will. But it's all, I always say, it's on personal preference. I would always advise to go with the will, but it's always the client's decision. So it's all on personal preference.
Related, I've got the situation where I have no real estate. And I guess I think of a trust much more when you would have something like real estate or stocks and bonds, things that would have to be sold.
So if I will say, so wills also takes care of stocks and bonds and things of that sort. But if you have, let's say, you own more than 5 homes, your best bet is to have maybe a trust, because that can be easily distributed a lot better than it will be a will. Not say that the will can't do it, because it most certainly can. It most certainly can iron out exactly what you want. But if you have more than at least 5 houses, then I will say maybe trust may be in your best interest. Or if you own, depending on the amount of stock that you have, the amount of bonds you have, a will also take care of it. But if it's like Bill Gates money, I think trust would be better.
Just on trust also, if you have a beneficiary that has a special need, and you want to get that trust into another trust for the beneficiary that needs it, if you can do that better with a trust, because it'll go straight from your trust to that trust. And you set it up, you set them both up at the same
Yeah, so yes, but it also varies on like what the situation is and what property or assets or whatever a person has. But I would say that the special needs trust, which is correct, that there is something like that does exist for trust, but they are also very, very, very complex, very, very nuanced, and tough to deal with, but it is something that can be set up, but also will cost a lot more money than it will. So, but again, it's all on personal preference. Personal preference. Oh, yes. Did you have a question?
Me?
Yes.
Oh, going back to the legal aid thing, do they count, like with her Medicaid thing, or do they count your accounts and investments and all that in with that, or?
Assets are, yes ma'am, assets are included. However, if you do get, like if you pay for prescriptions and stuff like that, that is a deduction that actually goes in your favor and that you get a credit for that. So if you're on Medicaid, you get deductions for that as well. We do the best we can to make you qualify for us, essentially, because we like to help people. Like, I like to help people. So anything that I can do to help you, I'm all for doing.
How about individual can, for instance, any individual can give to the fixed income people, like who receive a Medicaid? For instance, if I want to give to the help of them, can I give to them like a house to them or something like that? Is that possible, or you cannot give it to them, or if I do, then they're gonna lose their benefit? Because they have a fixed income, they can only get so many dollars to receive Medicaid. So if I want to help them to say pass down to the house to them, is it possible they can get it or they cannot get it because that's gonna be more than $2,000?
So the house, when it comes to like the disability and supplemental security income, that asset will not count because it's a house. But like if you have money, like in a bank account or something like that, or Social Security like to do want.
Give them a house.
Yeah, you can. Okay. Yeah, you can bless them with a house. You can bless them with a house, and they're not going to say, "Well, you own a house, so you have this house's house." No, they're not going to do that. Yeah, you can do that. That'll be fine. Yes, ma'am.
How about people that are not citizens of this country? Does that play into any of this? Does that affect any of this, or even illegal aliens?
So when it comes to our services, if someone has a green card, we do have, but you have to be a U.S. citizen in order for us to represent you or help you with whatever legal matter that you have. Unfortunately, our office doesn't handle immigration. Any more questions? I know you're probably hearing me talk. Oh, no, you're not. You're not.
Did you bring any business cards?
I have as many business cards as you want. So yes, I do. I do.
We're going to sign up, everybody.
By all means, do so.
I do have a question about, like your funeral arrangement wishes.
Go.
Is that something that should be a part of your will or trust, whichever one you have? Is that a separate document or what?
So you don't need to put it in the will or a trust. You don't have to have that information in there. However, I don't think it hurts. So I always put it in there just to make sure that Jasmine, make sure that your funeral arrangements are handled by Pope's Funeral Home, or you get buried at whatever cemetery. So yeah, it can be put in those things, just to make sure, in writing. When all else fails, put it in writing. Yes, sir.
I had a question submitted from someone online.
Oh, I'm online. Okay.
I
Yeah.
say that so that you'll understand. I'm not sure exactly if I know where they're coming from or not, but they want to know: is it possible for a spouse to get custody of non-biological children? and the way that they asked the question, can the and she's specifically talking about non-biological children that belong to a partner, can a non-spouse come in and get the kids?
So there's two ways that can happen. That can happen via adoption, but you would have to have permission from the actual biological parents to do that. Or you can, through custody, obtain custody of, the non-biological parent can obtain custody of that child, but that non-biological parent or spouse will have to prove that the other party, so if it's mother and father, mother has a boyfriend or mother is married to someone else other than the father, that non-biological parent has to prove that the unfitness of the father is the reason that that person shouldn't have custody of the minor child, and also explain the best interest of the child factors as well. So it can happen. It can happen. They just have to prove that that other parent is unfit and is in the best interest of the child to be with that partner.
Back to where you asked me, unfit parent, or unfit guardians, what is in detail, what do Virginia's state law concerns an unfit parent?
All right, so that's get into like litigation. That's get to like the fun stuff of what I like to do and make arguments for people. Literally a fact pattern. So I was giving examples earlier. A way to prove that someone is unfit is like a criminal history. So if they have a long history of like committing crimes or committing acts, that's a way to prove unfitness. Another way to prove unfitness if it's someone who has been on drugs or alcohol abuse or something of that nature. It's another way to prove. Another way to prove is someone not showing up for the child. So if there's been a multitude of missed first, like missed first baseball game or missed school, or don't give any type of money or monetary support to a particular minor child, that's a way to prove unfitness. Or every time that the child is with the actual biological parent, something happens. So the child comes back with bruises on their hands or bruises on their bodies or something like that. That's another way to prove unfitness. So it just depends on what the facts are and making the argument. So there's no set in stone unfitness. It's just, the definition of fitness is very broad. It's just a matter of proving that this child does not first belong with the biological parent, this particular biological parent, or both, and that the issue is so egregious that those two parents cannot properly raise this child, and it's not in the best interest. And I will also say, back to child custody, that makes me think, with child custody, it's not set in stone. And what I mean by that is there's cases that, say for instance, child is 1 year old. 1 year old, mother gets custody of the child. And mother gets primary custody, meaning that she has the child most of the time. And child turns 6 years old, and dad gets visitation time. Child turns 6 years old or time to go to school, well, that changes things. And by that changes things, there are certain schedules. So if dad was getting 2 every other week when the child was 1, okay, that's kind of fine because child is 1, easier to deal with. Daycare may not be as stressful, but once the child get into school, that's going to be a problem because the child need to be in some stable environment for at least 5 days out of the week, such that that child isn't going back and forth to houses affecting their schooling. And then to change that original order from when the child was 1, a parent will have to file what's called a motion to amend. And what that is, it'd be a motion to amend custody and visitation and to meet the standards of the standard to prove what is a motion to amend custody, it has to be a material change in circumstance. And the example that I just gave, what a material change in circumstance would be in that case, is the child has reached school age. And the schedule that was originally ordered at 1 year old no longer fits for the child, and it's not in the best interest of the child to operate in that schedule. But it also can happen within a year when it comes to material change in circumstance. So like if it's, child is 9, order is entered in 9, 10 years, and child turns 10, parents are fighting again over the minor child, someone can file a motion to amend again for material change in circumstance. And again, that comes to like the broadness of what that material change could be. So it could be that one of the parents moved out of state. And I will say that if you ever know anyone who is moving out of the state, military is a little different, but moving out of the state and has custody of the child, be careful because, and there's a custody order is in place, be careful because Virginia does not like when a child is removed from the state. That's an easy way to lose your child. And it could be a reason you just want to move, do something different, maybe better opportunities, things of that sort. But if you move, the court isn't going to take too kindly to that. It's not, and especially if it interferes with one of the other parents' visitation time or time. The court will likely change custody primarily to wherever the child was originally at. So always be mindful. I always tell people, I advise people, do not move if you absolutely don't have to, because that really changes the case. All the facts could be in your in your case to get you primary custody, but if you decide to move, especially when there's a pending court hearing, you could very easily lose your case. You're already walking in, quite frankly, with a losing case, because the Virginia courts do not like it, especially in the Hampton Roads. They do not like that. They do not like it. I believe you have another question?
No, we know an example where that happened.
Yeah.
Yeah.
Be very careful. Any more questions? Y'all been asking great questions.
Thank you.
Well, again, my name is Taquan Cates. I was so glad with the opportunity to give you this information. So, that's my contact information on behind me. I do have business cards. If you would like a business card, you can just come up to me and I give you one. So thank you again and have a good night. And hope to come back to you all soon. And I do have applications as well. I will give to Ms. Renee or Ms. Blanks for you all to